Hello, everyone. Welcome to our fourth revision lecture. I think yeah, how are we doing today? How has your day been and what's it's like in Hong Kong? So I popped in the chat what the plans for today are. We're going to go through the rest of the slides on Nemo that principle, and then we're also going to answer two questions on that. We're going to answer one essay question as well as a problem question. So you have an understanding of what the principle is and how you're able to answer questions on that. I think okay. Yeah, so I got some questions here. Let's address those first. Remedies under CRA, should you use CCR or use both? Use both. I think for the CCR is the one that requires it could be provision 50 if I can remember correctly, and that's the provision that requires the seller to provide information to the buyer. So that's the provision you're talking about in relation to the CCR ICA, yeah, the 2013 regulation. But you need to focus more. Mention the CCR ACA, and then focus on sections, the relevant sections of the CRA. So yeah, also relating to description and quality, do you need to talk about section 12? Section 12 is about title, isn't it? So, oh, you mean under CRA, do we need to talk about section 12? I have to, yeah, let's see what we've got there, section 12, because it's an open book exam, you're going to have access. I think, yeah. It's section 11, 9, and 10 for the CRA, but let's see what you've got in section 12 there. Pre-contract information included in the contract. Of course, yeah, that would be very helpful for determining what the terms of the contract are. And it aligns with the provisions of um it aligns with the provisions of the CCI, the regulations, the 2013 regulation. So I don't want us to waste so much time talking about other stuff. We need to cover this topic. Those are just yeah, yeah, pre okay, thank you for reminding me that it's pre-contract information. So yeah, let's continue from where we left off. So we're looking at this scenario. I think I've talked through it yesterday. The defendant wants to raise money for her car. She has the dealer to find out. And this case goes to show the length the courts will go to protect the owner, to protect the interest, ownership interest. So she signed blank forms, and you would think she's culpable. She made this happen. And the dealer was dishonest. He really was a reputable person before, but he was dishonest in this case. So the dealer filled in the rest and did that. And the court said the property still belonged to him as she had not been negligent in signing the document. You would think she should be held negligent, but that's what the court said. So the next exception there is disposition by a mercantile agent, someone that is in the business of selling things of this nature. So if that person, and the key provisions here, the key words here are um, if uh, when the mercantile agent in possession of the goods, when is acting in the ordinary course of business, that sale will be valid if there is as if there was express authority. So this is one of the exceptions. We want to ask ourselves, who is a mercantile agent? Is a person who deals in the ordinary course of business, someone who sells things. So a bike seller, that would be a mercantile agent, someone that you've known, you has been known to do sell things like that. So he must be acting as a mercantile agent. And there's been that distinction in the case law that provides that even if he doesn't have the right and is pretending to be, the innocent party may be able to still get title in that case. We're going to dig into this deeper when we're answering the questions on it. So the agent must be in possession of the goods or the document with the consent of the owner. And what this means for cars is it has to be the registration documents, the car itself, and the keys. So all of those must be in the possession of the mercantile agent, and that's only when he will be able to sell us that. And we also know that the person buying was buying good faith. And one of the ways to put him on notice to show that there is no good faith is if he's buying the item as a at a throwaway price or at under the value, under market value. In that case, we're going to say, yeah, there's no good faith here. Something should have this is something that should have seen as being suspicious. Why is he selling for so low? So if it's a car that is normally worth £2,000 in the market and you're buying it for £200, you should be put on notice, and there would be that presumption in that case that you are not buying in good faith. Yeah, we say it must be in possession of the goods, and the authority on that is Beverly Acceptances and Oakley. And in the question we're going to be answering, we're going to see that in one of the scenario in the second question, he actually wasn't in possession of the goods when he sold it, and that was what affected the title, his ability to pass on good title to someone else. So he has to be in possession of the goods, possession of the title documents, possession of the keys before he's able to dispose as a mercantile agent. And those things have to come into his possession with the consent of the owner. So we've got the statements of the court per Lord Goff in this authority that the relevant sections, yeah, we know it has to be with the consent. It has to get all of these with the consent of the owner. So by the to make this, and it must be authorized to deed to sell the same. So in this case, the plaintiff the owner of the goods here referred to is the owner with the consent, whose consent the agent is in possession of. We're going to, if he got it through a thief, that would really be different because that a thief couldn't pass good sight on a normal day. So what this is an example of what the scenario could look like. In possession with the consent of the owner gives it to the agent sells it to buyer one, sells it to buyer two. But this is problematic in the sense that when we're talking about the consent, how will the buyer that doesn't have any pre-information on the parties, how would that buyer know how he got the document? All the buyer is concerned with is there's a document and he has it. That he has the document with the consent of the owner. I'll lay this issue to rest, the issue of the assessment questions on Monday, because I see that we've been going back and forth on this and it's taking too long. I want us to be able to cover what we need to cover. I know that's important to you. I've said what it is before, and I just want us to be able to cover what all we need to cover. So again, the problematic issue with this is that how would the buyer know how the dealer got the documents in his possession? So the dealer was left, in this case, he was left with a car, but not the key. And he locked the registration document in the glove box. And the court said that is not having possession of all those items. So good title will not pass. So disposition by a mercantile agent, what if consent has been withdrawn? And that's what Section 2G provides, that it should not be effective against someone who has no notice of that withdrawal. And I think this compensates for the lack of clarity with the last point. How would the buyer know that they have all those things with consent, have that legally? But if there is a consent that has been withdrawn, it has to be, it would avail the owner if the third party that buys the property has notice of that. And Section 2(4) provides that there will be a presumption of consent in the absence of evidence to the contrary. So that does a bit to protect the interest of the innocent buyer. Now we want to move on to talk about sale under avoidable tie two. So when the seller of goods has avoidable tie two, meaning that there is been a misrepresentation or something that makes the contract voidable, meaning it has to be set aside before it can be void. It has to be avoided by the innocent party. So it could be due to fraud or misrepresentation, but not where the contract is void. And we've seen inconsistencies in cases on this. Some of the cases on these are Ingram and Little, Lewis and Avery. There's also Sundi and Lindsay. We're going to be applying those in the context of the question. So, Section 23, still moving on, talking about sale under avoidable title. The contract, the passing of title between the person that has avoidable title and a third party is valid until the innocent party sets it aside. So, like I said, this is very different from the case of mistake, if it's void for mistake, per Ingram and Little. So there's been a lot of controversy. If you're answering a question on this, you need to engage well with this part of the question. When you're talking about avoidable title, you need to consider cases and distinguish between cases that are face-to-face transactions as well as cases that are that are over the internet or through mail. So what we see, the position of the law is put forward in the case of Lewis and Avery in the sense that the court said when you're dealing with someone in a face-to-face transaction, you're dealing with the person in front of you, not the person you hope they are. But if it's in a distant contract, you're dealing with the person they pretend to be. And I said we want to see your ability to engage with the difficult aspects of the question, the difficult issues. So you might want to cross-reference Ingram and Little with Lewis and Avery. We know that in the case of Ingram and Little, the court said the ladies in that case, made an extra effort, made an extra attempt to cross check to really identify who the person in front of them is. So, looking at the authority of Ingram and Little, it's been criticized because the court said it was void for mistake, not voidable for misrepresentation. And some people even said it was because the court took pity on the little ladies, the ladies involved in this case. So these are some of the areas we would expect you to spend some time to really break it down and tell us what complexities we're seeing here. If the thief by misrepresentation or fraud gets a voidable title, you know the owner, the original owner, can set aside the contract by giving notice. But then the question is, what is sufficient notice to avoid the rogue's title? Again, that's controversial. What is good notice could be telling the police, reporting as a crime, but it's not everyone that would know that has happened. So it's again a controversial issue. And we know that there's the HPI, it's further down the slide. So let's talk for now about a seller in possession, which is another exception. If you as a seller, you have sold something to a buyer A, and the buyer A has not taken delivery. This is one of the facts in this revision question we'll be answering. If buyer A has not taken delivery, you as a seller, because you've still got delivery, you're able to sell the goods to a second buyer. And if that one doesn't take delivery as well, you keep selling until one of them gets the delivery. And the last buyer, the first buyer to get delivery, will take good title because again the law is trying to protect commercial certainty, commercial convenience, want people to be able to deal freely in the market. So this is what the provision is. But you have to be sure that we know the capacity in which that seller is selling. He has to be selling upon his authority as a seller. So we've seen a case here where the court said the authority, the claimant revoked the authority to sell, uh, and the court said the good title passed. So we see how the law has done a really good job of protecting the ownership rights of the innocent owner. The court goes through an extra length. So the flip argument to that is the sale by a buyer in possession. So again, when a buyer has not done all they need to do to get good title, so maybe they've paid part of the money, they've dropped a check, and that check has not been verified, and the buyer has possession of the goods, they are able to pass title to another person. And again, it's just the law trying to not force people to go to extra lengths to verify the interest of the ownership of the person selling to them. So yeah, Section 25 is the provision on the sale by in possession. Again, we've got an authority here. If the voidable title has been avoided, but the other person does not have notice of that, is still able to pass good title. Yeah. Now the question is, can that claim defeat the owner's title of a stolen car? The court said they have to have possession through the normal means. If the item is stolen, they don't have the consent to have the item, so it's different. The court said this cannot defeat title under Factors Act or the SGA. Hire purchase or conditional sales. With this, title doesn't pass to the person in possession until they fulfilled some conditions. Maybe pay all the sums payable under the contract of hire purchase or fulfill the condition attached to the sale. So under this exception, where the disposition is to a private purchaser, that disposition will have effect as if they are the owners. We've talked about this when discussing section 12 on Monday, so I don't want us to go into too much detail here. We know it has to be a private purchaser per section 29, and a private purchaser is someone that is not in the business of selling uh, cars or selling things of that nature. So there are some conditions to it. We'll be breaking that down in the answer. Now, I said if you're answering a question on this, you have to be sure on what that question requires of you. Does it require you to talk about ownership? Who owns title? Who has title in this item? Or does it require you to determine who has title and the remedies among the parties? So if the question asks you to do those two things, talk about ownership and talk about remedies for the people that couldn't get what they bargained for, then this section is relevant to your discussion. So the first thing is the innocent owner can sue in tort of conversion, if there's been interference with goods, you can sue the person that made the interference or the person they give it to, but you are unable to sue the person that's obtained good title. So there are some limits to that, and there's a limit to what you can get. You can only get value based on you can only get remedies or damages based on the value of the goods on the day it was converted, not afterwards. And with sorts of conversion as well, if the third party has made improvements, maybe they've repaired the car, maybe they've added value, you will have to pay them for the value they've added to it. So there's some restrictions on what you can do when it comes to the remedy. Um, a buyer from someone who doesn't have good title could also sue for breach of Section 12, breach of yeah, you don't. Section 12, we talked about on Monday. And if it's a consumer, you can sue under Section 17 for a business to consumer contract. This provision, NEMODA, has been criticized. People said it's not satisfactory in the sense that it's not very logical. if you look at it closely, there are too many separate and conflicting rules. For claimants, they may be able to sue on the different exceptions. They can say, "Oh, this was a sale by a mercantile agent who was a seller in possession." So I should, so they can do that. And we're just saying, why is this law so fragmented? It's even difficult to wrap our heads around it because it's fragmented. So the question is, should we revisit the policy to look at whom to protect? There have been lots of discussions about this with the law commission, but they've come to no reasonable conclusion on that. Because again, it goes back to the question of which of the innocent parties should suffer? Should it be the innocent owner or the person the rogue sells to? And what makes this really difficult is that at times we find that the seller would have sold, the rogue would have sold to a third party, and maybe they've taken off. If they've not taken off, maybe they don't have the money to pay it anymore. So yeah, those are some of the provisions of the act. So you're asking Lee, you're asking if the estoppel we're referring to is the estoppel by representation of fact. It could be by conduct, it could be by representation of fact. So if you as a person, you've acted in such a way that you have made it clear that you're not the owner of an item, see the Bishopgate case we looked at, then you will definitely be um, you will be liable for that. And that means you cannot come back to claim that you own the product. This is going to become clearer. Let me stop sharing that and move on to the question. So it could be a mixture of both. Could be a mixture of we're looking at the fact, of course, and part of the facts could be the conduct of the parties. It could be representation by word of mouth. It could be by the way they've behaved. So yeah, wanted to share. Forgotten to um questions. So let's have a look at the question. Um, let's have a look at the first one, number 7. We may lay down as a broad principle that wherever one of the two parties, innocent person, whenever one of the two innocent persons must suffer, it has to be the party who has enabled or occasioned the law. So if you're criticizing this, you're telling us that this is not really true because it's often not the person who has occasioned the loss, who has caused that person to occasion the loss. Yeah, that might be the case in the Bishopgate case, but in other cases, we see that the person that occasioned the loss often is not worth suing. So if you're faced with this question, I want you to pop in the chat box. What are the things you will be talking about? What do you think this question is asking you to do? Where's the starting point? While you get your thoughts together, I'll just make a start, and you start by referring to the provisions of Section 21. That's where the principle of nemodat is codified. So it provides that where goods are sold by a person who is not their owner and who doesn't sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods other than the seller has. So that's the rule. The first part of that provision is the rule. And the second part, which provides that unless they are precluded by their conduct from denying the seller's authority to sell. So that's the estoppel exemption. So you want to talk about the provision and look at why have we got this provision? It's because the court is often faced with two difficult situations. They have to choose from two innocent parties. Who is the person that should take the heat for what's going on? So in determining who should suffer the loss, they have to choose between the owner of the goods and commercial certainty or sanctity. They have to choose between that. And often there's a third party, a rogue, someone that is not worth suing, that would be preferable. That would be the person that we should actually sue. But we can't sue them because they're not available, or maybe if they're available, they don't have the money, they don't have deep pockets. So you either want to chase the person that has got possession of the goods, because if they've got no money to pay you, at least you can have recourse to the goods itself. Or yeah. So it's always that difficult situation. And we can see in the case of Bishop Gates Motto Finance, where the court said that no two principles in the developments of law have striven for mastery. And the first is the protection of property. No man can give a better title than he himself has, while the second one is for the protection of commercial sanctity. Again, you're reiterating that these are two conflicting valid aim, goals, valid aim. So we know that the person who takes in good faith and without notice will get good title. But again, who is that what's going to happen to the owner of that thing? So after summarizing, I mean, talking about analyzing that provision, the first part of Section 21, you might want to mention that there are this rule, Nemo, that had missed several exceptions. In our case, six of them, and you might want to touch on each of that one after the other. We know that the Crowder Committee, they've criticized the exceptions to the Nemodat principle. They say it's not based on equity and justice. It's just based on technicalities that you may not be able to defend if it comes to it. So start by talking about the first exception, which is estoppel. That's when the person is prevented from asserting they've got title because they've acted in a way that shows that they do not have that title. The authority, the case could be Moorgate and Mercantile Co. and Twitchings, where Lord Wilberforce said English law has taken that robust line that the man who owns the property is not, it does not own a general duty to safeguard it. And you can think about some of the examples we gave yesterday. So if I put my gold ring or gold wristwatch on a chair in the park and someone finds it and sells it to another person, it's not a good defense to say, yeah, you should have safeguarded or secured your item. No, I'm the owner. I'm the owner. Right. So that's what the Lord Wilberforce is saying in that case, that you don't have a general duty to safeguard, to secure your property. What this means is that we can see with the Estapel is very, very, very narrowly construed. There are some cases where you would think Estapel should apply and it doesn't apply. Again, you might want to refer to the question and say, who does this exception really protect? It protects ownership rights. It gives sanctity it gives precedence to the right of the owner. So yeah, in the case of Central Newbury car auctions, we saw that a rogue wanted to buy a car from the claimant. And you see what we're doing here? We're trying to touch a bit on the facts of the case because we think it's relevant to what we're discussing. So you can just select one or two cases to do this with. So you're not making your answer an analysis of cases. That's not what you're doing. What you're doing is analyzing the principle and the exceptions to it. So if some of the cases, the facts help you do that, by all means do that. So in that case, what he did was that he offered his own car on Park Exchange, and he completed a hire purchase agreement with a third-party finance company. So in this case, the claimant allowed the rogue, because he didn't know it was a rogue, right? He allowed them to take away the vehicle before the finance application response came through, and later that didn't come true because the road gave a false name, so it wasn't gonna happen anyway. And the court said the the rogue is able to yeah, sell the car, because yeah, we want to know which of the two parties should suffer for the fraud of the third of that rogue. In that case, Lord Denning was of the view that the law should fall on the claimant because it was careless, in parting with the car in such circumstance. So, but majority of the court f followed Lord Wilberforce and said that you're still able to claim ownership to, even though the argument before the court was you should be able to sell it off. The court said no, the owner wasn't very care. What culpability is not an issue here. Culpability is not an issue. The defendant was yeah, Lord Wilberforce just said they are able to assert their ownership over the defendant, and it is up to the defendant to pursue the rogue to ask them for the vehicle back. So that's tough luck. Again, like I said, the exception of Estopel is narrowly construed. The courts go to great lengths to determine what amounts to Estopel. So the loss in this case fell on the innocent purchaser. I mean, we said they could chase the rogue, but yeah, what's gonna come out of that? So the party that parted with the vehicle to the rogue, with the parted with the vehicle to the rogue, the claimant, they were able to still retain their title. And we know that where the owner gives possession of his goods to a third party, the law is that it does not represent to the general public that that party has the authority to sell them. And you might think this is sensible because that's the way commercial transactions work. We shouldn't be put on you as a owner of an item, you should be able to relax. We know the concept of caveat emptor, buyer beware. That's what Estopel is trying. That's the line, the rhetoric that Estopel is trying to force down our throat. So they're saying that you're not negligent to give your items to someone if um, if the person sells it. So I'm looking at can I conclude this way for car and cardware? The court should not rule to punish the owner because of the carelessness is entitled to be careless of his goods. I think that's what the court are saying. I mean, they didn't put it this way, but it's just like we shouldn't have to be we shouldn't have to be extra cautious with the way we behave as owners. It's just too onerous. That would deter people from owning items. And I want us to look at the broader context of things because this is one of the ways you can elevate your performance. You can think about why is the court going through extreme lengths? Who benefits from this provision? I ask you that question. Who benefits from this extreme protection? Going by the doctrine of Estopel, you see that with higher purchase, there are large industries doing this, there are large companies doing this. And the business model is that you, as a higher purchase company, you're in the business of giving your goods to someone to hold on to have possession. And they do that until they pay you back. So if the court in this case is saying you are careless by giving your goods to someone else to be in possession of, that would hit that large industry of hire purchase or bailment or conditional sales, etc. So the courts do not just make decisions, if that makes sense. They always consider the broader implication of that decision. What we call, I think there's a term we use for that. They're looking at the public policy aspect of it, and then there's a precedent aspect as well. So if it sets that precedence, then that means the industry of hire purchase or some of those other industries could crumble. So what they're trying to say now is that by giving your item to someone else, you're not being careless because there are some businesses that are mainly built on that model. So finance companies, let's just talk about one of the ways where the court also has really gone to the extreme in the interpretation of what Estopel is. Very narrow, is narrowly construed, and that's one of the ways you can criticize that provision. So finance companies set up something called a HPI. That's like a database, a group which finance companies belong to. So we know that in the UK, 98% of finance companies in the industry belong to the HPI. So what the reason they've created this database, this body is to register all hire purchase agreements so that the information could be shared between all dealers who are members. And the reason they want to do this is just so they could protect themselves against buying cars from people who are not owners or who have not completed payment of the item. Because in the UK, you see lots of really beautiful cars in people's driveways. These are on hire purchase. That's what lots of people do. Or maybe, yeah, hire purchase. Or there's the other one. But it's just the one that you've not really paid for the car, or even hire. It could be a hire purchase or a hire. So what they do is to register all that. Seems like someone has popped something in the chat. So yeah, in the case of Morgate and Mercantile and Twitchings, the claimant entered into a hire purchase agreement with a customer, but he did not register with the HBI. And it goes back to the question of, was he careless by not registering it? So what happened was the customer sold the car to the defendant, and the defendant was a cautious person. But caveat emptor, this buyer was caveat. He was very careful. So he checked the register and could not find his car there. So he just took it that yes, so this car is not under hire purchase or whatever. But remember, we said it's just 98% of finance companies that are on it. So 98 is not 100%. So you wouldn't, and you don't think all of them will do that. So what the defendant said is that the claimant should be stopped. They should be prevented from asserting ownership because they were negligent in not net registering the agreement with HBI. It was held in that case that this was not negligence and the claimant was not stopped from asserting their ownership. So you can see how narrowly construed this principle is. The claimant's actions may be seen to carry some elements of fault and blame if you look at it closely. But again, to the comment someone made earlier, they said you are entitled to be a bit careless with your goods. Good luck on that one. But that's what this authority, Moorgate, Mercantile, and Twitchings is about. We've also got another case, mercantile credit and handling. In this case, the person wanted to raise money on our car, so she left a signed blank credit application for with the dealer to just check, sample the market, and let me know how much you should be able to raise from the application. This was a respectable dealer, but maybe he was pressed for money. So what he did was he committed a fraud, and he got the finance made that, and the court decided that leaving the signed form was not negligent. You can imagine. So it just shows the extremes that the courts have been prepared to go to in limiting the application of uh Estopel, the Estopel exception. But you might also want to refer to a case in which this claimant was like, it was borderline careless. It was very much careless. The Eastern distributors and Goldring, which is a different case entirely. It's different from the other fact because he went out of his way to misrepresent that his ownership of the car is no longer his, that he has sold the car to the dealer because he wanted to raise money. We talked about the fact of this case yesterday, and the court said, yeah, this one is stopped. This one is a clear case of estopel. So the court said he lost the right to claim ownership of the car because he misrepresented that the car doesn't belong to him. So you can see that the threshold is very much very high. Yeah, because he wanted to commit fraud. Now you see that estopel supports the original owner. So now, if you're having a tally, you say one for the owner in relation to Estopel. So you also want to talk, remember we said there are six exceptions. So you want to move on to talk about the sale by a mercantile agent. Again, this is a very difficult one in the sense that you want to, I mean, not difficult for you in explaining it, but it's a complex area of the law because who is a mercantile agent? How do we know that they're selling us that? And how do we know they've got consent the right way? A mercantile agent has been defined as the one who, this is the factor act exception. So it was defined in the act as someone who has the authority to sell goods or consign goods for the purpose of sale to someone else. To apply, that person must be authorized to act in his own name without disclosing his agency. And the question is, how would you know as a seller, as a buyer rather, how would you know that they have that authority? How would you know? So if there is an innocent purchaser, for them to acquire a good title, the agent must own the goods, the documents, and in the case of a car, you must have the keys as well with the consent of the owner. So how would you know? They've got all these documents. How do you need to see a signed document to show that they've got consent? Well, that's really difficult. So it just makes it very difficult for the buyer to get title. So if you've delivered your goods to a mercantile agent for the purpose of repair, because you know some mechanics, they double as repairers and they also sell cars. So if you've delivered your own car to them to repair, they cannot pass title because you are giving them the car not in their capacity as a mercantile agent, but you're giving it to them in their capacity as a repairer. So if that's the case, then no consent, there's no consent to sell that vehicle. And if they sell it, an innocent purchaser will not get good title. So the authority on that is Pearson and Rose and Young. In the case of second-hand cars, a mercantile agent that has possession of the car, the logbook, and keys, that would be apparent consent. We would normally think is apparent consent. But in the case of Pearson and Rose, the court held that the owner of the vehicle retained title even when the agent had all those three things. And the reason the court said that was because he tricked the owner into leaving the logbook. Now, how would the buyer know whether it tricked the owner to get them or not? So this is the complex area that you might want to focus a bit on when you're answering the question, if you understand what I'm saying. So you want you to be able to identify the complexities in the law and see how this visits hardship on an innocent buyer. So how would you have knowledge that the agent does not have consent to sell the item? And therefore they'll be left out of pocket if they could not recover from the rogue or seller. And when these things happen, you really want to pursue the person that is culpable and has money to give you. In most cases, the rogue doesn't have the money to give you, or they've disappeared. So you might keep referring to that to show how difficult, how onerous the provisions, the conditions are on an innocent buyer. You might also want to touch on one or two cases on that. One of that is the Stadium Finance and Robbins, where the court said the owner did not leave the ignition key and accidentally left the registration document locked in the compartment. And the court still said the subsequent sale by the mercantile agent did not pass title because the car and the documents and the key were left to him with consent. It's difficult, very difficult for the buyer to know if they got consent or lacked it. And I think in Open Heimer's case, Open Heimer and Attenborough, that presents an interesting twist to it. And this Open Heimer's case is hard to reconcile with the above case. In that Open Heimer's case, a diamond broker pledges the diamond left in his possession to someone else. And normally you would think brokers don't usually have the authority to pledge diamonds, but the scope of business, ordinary course of business of a mercantile agent was broadly construed in that case, and the pledgee, the person that he was pledged to, was able to obtain good title. So aside from the fact that it's difficult to know how the mercantile agent got access to those three things, the document, the keys, the item itself, Now we're not even sure anymore because now you're saying a mercantile agent, which you wouldn't, they sell, they're not pledging things, but you're saying they're able to pass good title. So this case is really good, open AMA's case to show the controversy in law, to show the complexity in law. So, but you would just want to say at least there is some certainty in a way with this case, because if you're able to prove that this is in the ordinary course of business of that mercantile agent, you will get good title. So that would seem to be a fairer test generally to protect the innocent purchaser in good faith. But nevertheless, in Open AMA's case, they don't usually have the authority to pledge. So would they don't usually have the authority, but the court still said it's in the course of their business. If they're able to pass title, they should be able to pledge, even though they don't usually have that. It's not something they usually do. So a purchaser in good faith without notice is also able to acquire good title to the goods. So this is the next exception, being the third one we're talking about. We talked about Estopel, we talked about sale by mercantile agent. Now we're looking at um, the person with a voidable title. So contracts are automatically void if there has been a mistake or if the contract is illegal. So if you've entered into a contract for an illegal purpose, it is void. You cannot pass title. So you cannot get a subsequent title from such originating contract. But courts have been very careful in distinguishing between contracts that fail, that are void for mistake, and one of those cases that is controversial is Ingram versus Little that I touched on while talking about the slides. In that case, the sellers dealt face to face with a rogue who misrepresented his identity. They were able to establish that they were intended to deal with the person he misrepresented himself to be because they took extra steps to verify his identity. They went to the phone book and looked through that and saw the name, but unknown to them, because the phone book doesn't have a passport or a picture, they were not. They thought it was the person they claimed to be, and the court held that the contract was void for mistake. So a subsequent innocent purchaser will not acquire good title. In that case, Ingram and Little, Devlin LJ was of the view that a fairer approach would have been to apportion loss based on culpability. So don't let it be a decision of either an innocent purchaser or an innocent owner. Let it be maybe both of them and share the cost of the vehicle between them. But that it was just a suggestion that wasn't pursued. So the case has been criticized. Like I said, some people were of the view that it was because the court took pity on the little ladies, as they were referred to. You know the way we feel about our older people, little old ladies, as they were called in that case, and it's been criticized. But we know that the current position is that if you're dealing face to face, you're dealing with a person in front of you. So if they've misrepresented themselves to be a star, they've misrepresented themselves to be, say, Elon Musk. If you don't have a TV, you would know what Elon Musk looks like. But if they've misrepresented themselves to be someone else, that doesn't matter. You are dealing with a person in front of you. But if you're dealing with someone over a distance, say maybe someone in Hong Kong, if I'm dealing with someone in Hong Kong, or you are dealing with someone in maybe Canada, then I would say we are dealing with a person they pretend to be. And that's the position of the court in Louise versus Avery. In that case, the person that they contracted with showed them a photo card from Pineville Studios saying that I was a famous actor, and this was held to be a contract that is voidable for misrepresentation. He lied, so this is not a mistake. There's no mistake. He was the one that lied, and so if it's voidable for misrepresentation, it cannot be void for mistake. So if the determination of when title, if title passes to the buyer would be if that sale to the innocent third party comes before it avoids the contract, then good title will pass. If it comes after, it's debatable because we want to know was there good notice given to the buyer. So that is a gray area distinction between voidable for mistake and voidable for misrepresentation, rather, sorry, and void for mistake. And as well, the distinction between if you're dealing with someone face to face or over a distance. And there's also a distinction that we could see in Sundi versus Lindsay, where I think that just goes to the third issue. The first one, distinction between mistake and misrepresentation, and the second one, when you're dealing with someone who is further from. I think those are the two um, main distinctions there. And you might look at the case of Sundi and Lindsay, and where the court said the identity of the parties could be fundamental, and the agreements may be void as opposed to voidable if it's for mistake, but if it's for misrepresentation, it is voidable. It's been criticized by the courts in several cases, but when it came before the court in Shogun Finance, uh, the House of Lords failed to clarify because there was a split decision where they said they want to preserve the distinction in treatment. They want to present it. So that just shows a complexity that you might want to focus on when you're answering this question. There's another issue that could give rise to difficulty, and I think that's the third point I wanted to make on the issue of voidable contract. How can you avoid a contract? How can you give notice to the rogue that you intend to avoid a contract when they've taken off? They went into they've gone into the sunset. So, and very hard to trace. In the case of Carr and Universal Finance and Caldwell, the court held that if a country had, if a not country, if a contractor, a party to a contract, a party had done all they could to let the rogue know their intention to rescind the contract, it will be avoided. So in our own case, it would be sufficient to notify the police or maybe the AA, the main party you go through when you're buying cars, that the seller of a car intended to avoid a contract rather than telling the rogue itself himself, because the rogue is a rogue anyway. Whether you avoid it or not, he's still going to proceed to sell it. That was the intention. So even if you've done that, it's difficult because it may not protect the rights of an innocent purchaser without notice, because majority of people will not check with the AA or may not check with the police if a car is stolen. How many people go to the police when they're buying cars? But even where the contract has been avoided, there's that likelihood that the rogue will remain in possession. And if he remains in possession, remember, maybe he has given he has misrepresented himself to be something else. He's a buyer that has got possession. He's a buyer in possession. So that's also another exception under Section 25 of the Act. So it provides. So now this is the fourth exception. So where possession has passed to a buyer before title pass, if it sells to someone else, that person buys in good faith, then he gets good title. The most common use of this principle will be where under the agreement the buyer has not acquired good title until it pays for them. So it could not pass on good title with this exception. But because it has possession, it may be able to sell as under Section 25. But there are five criteria that have to be met. So you might just touch on this one after the other. The first one is the person selling, that buyer. must have bought the thing or agreed to buy it. And then the second one is he must have obtained those things with the consent of the owner. So it doesn't matter if he has misrepresented himself, he still got the consent of the owner. So he must have got the title, the documents, the keys if necessary. So that's the second consent and possession uh, consent rather. Now the third one is the issue of delivery. You must actually have possession, hold the goods or the title document of those goods to the innocent sub-purchaser. So he's got possession himself, and has now given this to the innocent sub-purchaser. So the buyer of the goods, the fourth one is that he must be acting in the ordinary course of business. The buyer must be acting in the ordinary course of business. If that's not the case, then this section will not apply. And the final point is you must have bought in good faith. You're not buying in good faith if you're paying under market value. You're not buying in good faith if you know that contract has been avoided. You're not buying in good faith if there's anything that should put you on notice on what you're buying. But you're not paying attention to that. So we got the authority of Newtons of Wembley and Williams, where the original owner of a car had avoided the contract of sale to the rogue. So you would argue that no title could be acquired under Section 23. But innocent purchaser was still able to acquire good title under Section 25 because the rogue sold at a market, holding himself out to be a mercantile agent, even though it wasn't one. So if you're selling under the Factor Act, if you're even pretending to be a mercantile agent, you're still able to um, pass good title to the innocent purchaser. So that decision proves good things. It provides two things. The first one is a party can acquire title by operation of Section 25, even when voidable title has been set aside under Section 23. So we see that it's a serious limitation of Section 23. Uh, yeah, so it's just the complexity of the law on that. So that's the first point. You can acquire good title under Section 25, even though you've been denied that under Section 23. And I know that I said earlier that what people do is to claim for more than one of the exceptions and see which one sticks. So that's what lawyers do. They present competing arguments just to see which one of the arguments the court goes with. So the second point from that case, from the case of Newtons of Wembley, is that the effectiveness of Section 25 is limited by a very unusual interpretation of that section because it requires that the buyer in possession must be selling as or appearing to be a mercantile agent. So he must be selling as, or he could pretend, appearing to be a mercantile agent. But we see in the case of National Mutual Insurance and Jones, where it was decided that the provision could operate only to defeat title of an owner who has entrusted possession of his goods to a buyer, not to one whom goods have been stolen. So again, this adds an interesting twist to the equation. He must have obtained the possession through an honest means. It shouldn't be one that he got if he has stolen the item. So it could be every other way, maybe misrepresentation, etc. But if he had stolen it, yeah, he won't be able to get title. So Section 25 provides only for people who have bought or agreed to buy goods. So if it's a case of hire purchase, then it's a different case entirely. And for that, we've got Section 27 of the HPA. Now we're moving away from the SGA. We're moving on to Section 27 that we've already touched on when we're discussing Section 12 on Monday. So Section 27 aims to protect private purchasers. And remember, private purchaser here is different from the definition of a consumer. A private purchaser is someone that is not in the business of selling cars. a person that is not a car dealer. So three main conditions to be able to come under Section 27. The first one is the seller must be hiring the vehicle under a hire purchase agreement or a conditional sale agreement. And secondly, the purchaser must be a private purchaser. That's defined in Section 29. I've it talks about the the meaning, someone who is not in the business of selling vehicles or dealing in vehicles. And also, he must be unaware of any agreement attaching to the vehicle. So this points to the issue of innocent purchaser without notice of the defect in title, something similar. But there's a limited protection of an innocent buyer regarding this, and it's been criticized that there's a limited transaction that could fall under the statute. When we look at all the exceptions, there are just a limited number of transactions that could fall under that. Yeah, it tends to go more in favor of the owner, the original owner. Um, Looking at the way we transact in the current age, it's just yeah, by seller in possession, by buyer in possession, mercantile agent, sale by person with voidable title, etc., etc. It's just really difficult for an innocent purchaser to get title. We know that under Section 24 SGA, title may pass to a subsequent buyer in good faith without notice if he acquires a good title, even when the seller has entered into a contract which has already passed to another seller. But if in that case, for some reason, the seller did not pass possession of the goods to the first buyer, yeah, another buyer could get title. So one of the requirement is that there must be delivery. So you as a subsequent buyer, you must have delivery of the goods or the title document. So this means that a seller who sells to buyer one that agrees not to deliver until tomorrow, yeah, it could sell to buyer two. I think it's the case in the second question, the next question we're looking at. The initial sale transfers title to to buyer one, but under the Section 24 exception, the seller retain possession. If you get retains possession, then buyer two will get good title. And what would be the remedy for that? Buyer one would have to pursue the seller for the return of the money, total failure of consideration that we talked about in relation to Section 12. Um, if there is no way to get the money back, then he has lost that. So we can see in this case, there is a higher level of protection for the innocent second buyer over the first. And we could argue that the first buyer, by purchasing the item and not taking delivery, is a bit culpable. And that could be a rationale for saying, oh, this is fair. If you're buying something, be careful. But doesn't that go contrary to what we said earlier, that you are allowed to be careless with your goods? I don't know if you get the point there. So now we're being very strict with one of the innocent parties, the owner, the first buyer, by saying, yeah, if you had taken delivery earlier, maybe this wouldn't have happened. So you are culpable. Can we reconcile this point of view, this line, with the estopel exception, the first exception? No, we cannot. So these are some of the things you might want to point out, draw out in your analysis and say, the rules are not logical. They're just simply not logical and they cannot be defended in a reasonable way. They're just based on technicalities. The Law Reform Committee, in their 12th report in 1966, proposed the removal of the distinction of between void and voidable contract. Um, and they also wanted to reverse the decision in car and universal finance and cardwell. But the recommendations were not taken any further. There was also a recommendation to on the requirement for a mercantile agent. to act as a mercantile agent per the case of Newtons, of Wembley and Williams. But again, these were not taken any further. So what we're seeing is that, yeah, this statement that is the person that's caused the loss to sustain it, that's not shown in the way the courts have treated the exceptions. Some of the exceptions that have been drawn. There's the extapel that is narrowly construed, which can be contrasted with sale by a seller in possession. So it's just the number of exceptions are not defensible. They're just technical, and we cannot really say they've been logical. So whether a party acquires good title or not rests on what the court assume about the goods being in possession of who. Uh, Maybe the mercantile agent with deemed authority. There's that fine distinctions between void and voidable contract. There's that issue as well on how quickly an innocent purchaser, innocent party notifies the rogue of their intention to avoid the contract, or simply whether you take possession of goods immediately you're buying it, you're taking it. So there's also the requirement of Section 25 that involves an unusual interpretation of the statute, requiring the buyer in possession to be behaving as a mercantile agent before they can sell. So we can see from these exceptions that the courts have had to make a difficult decision between who should they throw under the bus. Should it be the innocent owner or the innocent purchaser? Should it be commercial sanctity or right to property? And what makes it really difficult, what makes it more complicated is the rogue who caused the issue, who this man, Ashhurst, is referring to, is often out of the picture. He has run away and he cannot be found. Or even if he can be found, he doesn't have the car anymore and he has blown the money away. So that the courts are often faced to determine who they're going to help, who they're going to protect. So the technical rules that we've seen developed are the court's attempt to protect those parties, but it doesn't always appear that the result is fair for all concerned. And we can see that the original owner gains more protection at the expense of the purchaser. When it comes to Estapel, we've seen that exceptional case where it was because the owner misrepresented, he participated in a fraud. That was the high threshold we saw. And the other ones are also problematic from the viewpoint of the purchaser. So the difficulty, what this court struggle with again, is choosing who to protect. So proposals for reforms are hampered because it is not clear. If they decide to protect the buyer more now, people are going to say, "Oh, now you've left the the owner hanging." So it's you can't win. It's a zero sum game, except for the comments of the court in Ingram and Little that said the blame should be apportioned. But we know that's not what happens. So yeah, that's how you would address an essay question. What we did was to start with section 21 and go on to talk about each of the exceptions, drawing out the complicated areas, some of the issues these have raised that need to be addressed. And that shows that there's no consistency at all, and there are some complicated issues that still need to be ironed out. So that's it. Let's quickly start. I hope we're able to finish this before we go on break at in 30 minutes ish time. And then when we come back, we're able to start with the next topic. So I'm assuming we've had the time to read this, but I'll give us 2 minutes to have another look. Yes, I'm assuming we've had the time to read that. So I think I've got some questions in the chat that I hope I'm able to quickly run through. So the first one is, would you confirm question 4 is put on the section Christine TV, private use, description and quality questions, and last sentence. So let's have a look at question 4 that you're talking about. Question 4. So Christine decided to purchase 40, she sees full. Yeah. So if she's buying it for her birthday, I think what we talked about in relation to that is it's a CRA if she's buying it for use as her birthday because it's a B2C contract. I think the first one we looked at. Okay, so that was the first one. And the second one was a, yeah. So it even says that supply of goods and services Act. Okay, SGSA. So let's go back. The first one. So it says in the title there, three, description and quality. This is a B2, so industrial. So this is the first one. The three is a B2B contract, which we apply the SGA. And then the number four, that's a domestic one, which is under is a consumer contract where you'll be talking about sections 9, 10, 11, etc. So I hope that answers your question. You're not applying both SGA and CRA. You're applying CRA because it's a relevant provision section. Yeah. So you can go back to watch the because this is recorded anyway. So now the next question there is section 25, work only if a rogue is involved, but if but not if a thief is involved, void. So what the distinction the court made in national mutual insurance and Jones is that the provisions could only operate to defeat the title of an owner who had entrusted the possession to a buyer and not one from whom goods have been stolen. So that's just a distinction the court is trying to apply there. That if you have stolen the goods, that you didn't get the title with the consent, but it's voidable when you misrepresented yourself. So what they're saying is, if you're a buyer in possession because you have not the seller has not waited until you've done everything you need to do before you can get title, then so I think the distinction you're making right in that is relevant. If it's a thief, if you have stolen it, you cannot pass title. So stolen, the person didn't have title at all. It's not void. But again, you might want to point out the controversy because if it's stolen, that's not just a question of being void. Because if something is stolen, there is no transfer, if that makes sense. If something is stolen, no. But if it's vitiated by mistake, then we can say it's void. Chill. So I hope that helps. Now, talking about the problem question, can you pop in the chat some of the things that come to mind in relation to the question about Albert? What are the main issues you can discuss? What are the main issues? So it's not very material anyway, in this case, to say B2B, B2C, because the CRA does not deal with NEMO that. So everything you need to talk about needs to go through the route of the Section 21 SGA, etc., etc. So can you pop in the chat? I'll be coming to that. So we see that Albert, he takes his car to the garage for repair. So because he's taking the car to the garage for repair, he's not giving it to that mercantile agent in his capacity as a mercantile agent. He's giving it to him as a repairer. So that is the first thing that tells you the direction of what the answer should be. So it tells Albert that he should check if he could get £15,000 for the car, and it says yeah, see what kinds of offer you can get. So we can see that it didn't part with the registration document. So remember in the exception or Factors Act, it needs to have the document, it needs to have the keys, and it has to have possession of the car. So he's not in possession of all those things, right? And we can also talk about Divina that sold the car. So let's get started. The question relates to the rights of ownership per Section 21 and the exceptions to the NEMODAT principle. So even if any of the parties are consumers, the CRA does not apply because it doesn't deal with NEMO. So it continues to be controlled by the old statutory provisions, the SGA. So now we're concerned with the NEMODAT and the exceptions. We see that the first exception to NEMODA is Estapel. And looking at how we've interpreted that in the previous question, the courts have gone to extreme lengths to construe it narrowly. It seems Estapel. So you are allowed to be careless with your goods. You're not going to be penalized for that. So merely parting with the possession of the goods will not be sufficient to give rise to the claim of Estapel. We got a case of Central Newbury Car Auctions and Unity Finance. Something more positive needs to have been done, and we can see that this was the case where that person misrepresented that he had sold his car because it was a grand fraud scheme. So it serves him right. So you see, Estapel is narrowly construed. In the first scenario, Albert takes his car to the garage for repair by Brian, who is a car repairer as well as a car dealer. But in this case, he just told Albert to find out if there were any offers to buy the car. As a car dealer, Brian is a mercantile agent under the Factors Act, and is someone who is in the ordinary who is in the business of selling, has the authority to sell or consign goods, and is able to raise security or money on the security of goods. So it is possible for purchasers from mercantile agents to acquire good title, but there are conditions to it. For Section 2 to apply, the agent must be with the consent of the owner in possession of the goods or the vehicle or documents of title, make a disposition or sale of the goods when he's acting in the ordinary course of his business. So we can see that in this, he's acting in the ordinary course of his business, but he doesn't have possession of all those things with the consent of the seller. And even at the time he sold the car, it wasn't in his possession. So it doesn't seem like that section would apply. It doesn't seem like that. The authority on that is Stadium Finance and Robbins. In this case, Albert parted with the vehicle voluntarily, but not as a result of any trick. But we see that Brian did not have the vehicle registration document. So the authority on that is Pearson and Rose and Young. The dealer needs to have the goods in his capacity here. So there's so many things kicking him in the leg. He has no leg to stand on. He didn't have the vehicle. He didn't have the title documents that he needs to have, and he did not have the car in his capacity as a mercantile agent. But what he did was to authorize Brian to seek offers. He didn't ask him to sell it. But even if he sold it and he's got all those other things, he may be able to still pass good title. In the case of Pearson, Rose, and Young that I talked about earlier, it was decided that when the dealer was selling without the registration document, that would not normally amount to acting in the ordinary course of business of a mercantile agent. Because to do that as a mercantile agent, you need to have access to all those three things: the keys, the car, and the title document. So it would not be deemed to be acting in the ordinary course of his business. Additionally, this sale needs to take place at the time that he has the car, he has the goods. The authority on that is Beverly, Beverley. So Beverly Acceptances and Oakley. At the time of sale to Craig, Brown is no longer in possession of the car. It's been taken by the owner. So it would seem that aside from having the car with the consent of Albert, it doesn't satisfy the requirement of Section 2 of the Factors Act to operate. So we can see that Craig will not obtain good title to the car. We're going to be talking about remedies later because if Craig doesn't obtain good title and there's total failure of consideration, he might be able to claim remedies under Section 12 of the Act, and also he might be able to claim remedies for that. Now, Albert sells the car. Albert has been busy after getting the car back. He sells it to Divinia, who is financing it with a hire purchase agreement with Win Finance. So what happens is that Albert is really selling the car to Win Finance, and then they'll release possession to Davinia, and when Davinia finishes paying all the money she needs to pay under the contract, then she would have ownership of the car. But currently, Davinia doesn't have ownership. So that's what happened uh, with a hire purchase agreement. But in this case, Divinia did not wait to pay all the monthly installments. What she did was to sell the car off after paying just the fourth one. So the car is not hers, but now she has sold it to Edwina, a car dealer. So the question I want to ask you is, one of what Nemo that exception applies here in relation to Divinia and Edwina? Do you think Edwina acquired good title, or does it remain vested with Win Finance? Remember, you can't give what you don't have. The Muda could not abate. You cannot give title better than the one you've got. So, what do you think? Do you think Divina gets a good title? Uh, Edwina rather. Do you think Edwina gets a good title under any of the exceptions? I'd like to see your comments on this in the comment section. Does she get a good title? Are you guys still with me? Does she get a good title? Selling to Edwina, the dealer, the car dealer. Very good. Thank you, Kai. What section have you relied on? Um, that's a very good statement of the law. I'd like to just mention in the assessment as you're answering, make sure you're also supporting your statements of law with an authority. So what section? Very good, Chung. So yes, Divina cannot get good title under Section 27 because that section is there to protect private purchasers. Edwina is not a private purchaser, so she cannot benefit from that. So aside from Section 27, and 29, which defines who a private purchaser is. You might also want to cite and authorities on this, Morgate, Mercantile, and Twitchings, who was still held to own the goods because they didn't register it. So she's not covered by this. But then we need to look at what if she can pass on good title. She doesn't get good title, but can she pass on good title, and to whom can she pass this on? So there are lots of authorities on that. There's the mortgage case I've talked about. There's the corporate finance and wider. There's also Stevenson and Beverly Bentic. So yeah, a private seller will get good title. So she sells the car on to Frank, who is the private purchaser. But in this case, Frank was being careless in the sense that he did not take delivery of the vehicle. So you can see the twist from a dealer, the car goes on to a seller in possession. So as a seller in possession, they're also able to sell to a second buyer. But before we get to that, Edwina is able to pass good title to Frank, and there's nothing in the act which says that the exception must take the delivery. Um, there's nothing in that act that says for you to get good title, you need to take delivery. So it will count as a relevant disposition, assuming he purchased in good faith and without notice of the right of win finance. He will acquire good title under this exception. He purchased it at a really good value. So we will think that, yeah, that doesn't put him on notice. But he did not take delivery. So even though he gets good title, he doesn't take delivery. So Edwina now moves on to sell that car a second time to Gwen. So we can see that Gwen can obtain good title under Section 24, which provides for transfer when there's a second sale by a seller in possession. So Edwina proceeds from being a dealer to become a seller in possession and is able to pass good title to Gwen, relying on Section 24 of the Act. So the basis upon which the seller retains possession is irrelevant. It is irrelevant. The authority on that is specific motor unctions and manor credit. So Edwina makes a second sale, but does not have a good title herself. So even though the first private seller, the first private buyer got good title, but by failing to take delivery, then the subsequent buyer could take good title. So the section operates to defeat the title of the person who allowed the goods to remain in possession of the seller. And you might want to point out that it's difficult to reconcile with the Estapel exception because now the buyer one, is being careless, but that's immaterial, isn't it? Oh, please hold on. Hold. Sorry about that. There was someone at the door, unexpected. So I'll just continue from where I left off. So we can see that through the delivery, failure to take delivery by the first buyer, the first private buyer, it just means that the next buyer could get good title, but the section operates will operate only if Gwen gets title. Do we know if Gwen actually got title or not? That's not very clear. That's I don't think that's clear on the fact. Does it say? It says Edwina sells a car to um Edwina sells the car to Frank, a private purchaser. No, I think it's before then. Okay. So okay, yeah. Edwina sells the car. She's experiencing cash flow. She sells it to Gwen. So we don't know actually if Gwen took possession or not. So that's something we should be finding out, but it's not clear on the fact. So if she did, yeah. So that's a difficult one to reconcile. You can see on the fact it doesn't say, but we want to know, has she bought in good faith? Has she bought at a good price? So she sold it to Gwen for £10,000. Yeah, cars devalue from 17,500 to franc to Gwen for 10,000. Yeah, it's up to you how you interpret that. Uh, but in this case, we don't think Gwen was aware of the earlier sale because we don't know. But 17,000 to 10,000, you can argue that this is a significant undervalue, which doesn't automatically mean that he's not gonna get good title. It doesn't automatically mean that. It just means that she's being put on notice, and it depends on how she's able to explain that away. So a drop of 7,500 seems quite significant. That should put her on notice. So there's a burden of proof that is on Gwen to show that she actually bought it in good faith. So as a summary, in summary, it would seem that there's no transfer from Albert to Craig because they didn't meet the exceptions under Section 2 of the Factors Act. Instead, it sells the car to Divina himself to purchase it on hire purchase. So finance in this case could be argued to get good title when the car was passed on to Win Finance for the purpose of Divina. Now, when Divina sold the car to Edwina, we've said it doesn't pass. So now we're trying to summarize what we've said. Edwina doesn't get a good title because she's not one of the persons the Section 27 HBA protects, but the exception applies to subsequent private purchaser in this case, which is Frank. So Frank acquires good title, but again, the challenge is he didn't take possession. So Edwina is still able to sell on to someone else under Section 24. So he's a seller in possession who is able to sell on to someone else. So title would appear to end with Gwen unless she did not buy in good faith without notice. And you know that's something we struggle with. And it was also something we discussed on Monday when we are talking about Section 12. If it's proven that you did not buy in good faith, you will not be able to take good title. So that's where um, it ends for the main part of the question. But remember, in the question, it says it's two parts. The first thing is advice on the rights of ownership. So that's what we've talked about. Ownership. Now it looks like Gwen has got good title. But there are some other questions left hanging. The first one, which is a question of remedies between the parties. Is there total failure of consideration? Who is able to sue for tort of conversion, and then the interference with act, and that's this next part we should be discussing. Now, on the question of remedy, looking at our analysis, Brian breaches authority be, with Albert because he agrees to sell the car to Craig, but because he was unable to pass title to Craig, this is unenforceable against and Albert, in this case, has suffered no loss because he managed to sell the car for more money to Divinia. So Albert has suffered no issue. Now, in terms of Craig, there could be damages in contract, in contract for them to get compensated for their loss, and this would be measured by what was suffered by the party. In this case, we can use the authority of Surrey, Surrey, and Bredero Homes, Bredero Homes. So there's therefore no claim from Albert against Brian because Brian didn't get the car anyway. But uh, but Craig had agreed with Brian that Brian would sell him the Corvette. So if Craig is purchasing the car for purposes wholly or mainly outside his trade or profession, and this is entered into after 2015, then there's that condition that is implied to the contract. So now we're looking at the CRA for the remedies, but the NEMO that itself was not dealt with by the CRA. So we looked in the first part of the question, we applied the SGA, but now we're looking at CRA because it seems like Craig is trying to buy as a customer, as a consumer. So the CRA will apply, and we can see that um, Brian had no right to sell the car. So what that means is that there has been a breach of that right and there has been a total failure of consideration because Brian has not been able to deliver the Corvette. So if Craig had paid for the car, he can recover the payment. And if there are additional losses incurred as a result of that failure to deliver the car, Craig is expected to re-enter the market to buy another car. So if he goes through any issues getting the car, then he can recover the difference in value from Brian pursuant to Section 51 3, which is damages for non-delivery assessed where there is a market available. And we know you can also rely, so that's Section 51 3 of the SGA. But because he's dealing as a consumer, it won't be relying on the SGA. So the sections you might want to rely on is section 19, subsection 9 to 11. And I think the main crux of that section is really talking about damages. So now I see that is 1245. So now we've talked up until the remedies that will be available to Craig. So he can claim for damages and for reasonable loss he has suffered as a result of that failure to deliver. So when we come back from the break, we'll be moving on to talk about the remedies available to, or not, remedies are not available to Albert and when finance. So you can go on break now. If you've got any questions, pop it in the chat. We'll address that when we come back. So, but we should be back at the top of the hour. That would be 9 p.m. Hong Kong time. See, I'm getting better at this. So see you all at 9 p.m. Yeah, welcome back from the break. Yeah, so we're still recording. Before we went on break, we talked about the remedies between in relation to Craig, and I said we're going to move on to talk about Albert and Win Finance. So this is not something that we will be overflogging because Win Finance got what they bargained for. There was no issue in relation to the transfer of ownership between them, the ownership to Win Finance. They actually got what they bargained for from Albert, and the car was sold to them for 18,000 pounds, and they passed that on to Divinia. So now that the car is owned by Win Finance and they've given it on hire purchase to Davinia, under which she has agreed to hire the vehicle and then it could become her home if she exercises the option to purchase. But she didn't do that. She sold the car on. So we can see that she has defaulted in the agreement. So she sold the car on. So that means there's a challenge with title with ownership. So in this case, she sold the car on to the Edwina for 16,500. That's at a good value. Davinia is not a dealer, but Edwina is. And remember, she's not a consumer. So this does not fall under the Consumer Rights Act. We have to go back to the SGA to think about what provision selling by someone who is not the owner, Section 12. So it's a condition going by the Sales of Goods Act, and because she's not a consumer, she cannot benefit from the CRA. So it would appear that Davinia has been in breach of that condition, and that could mean that there's been total failure of consideration. So she could repudiate the contract and claim damages. Again, the authority on that is Roland and Deval. However, in this case, Edwina has sold the car on, so she's not in a position to return the car to Davinia. So repudiation, what's that going to look like? No longer doesn't look like it's possible. And this is further complicated by the fact that we're not told if the Davinia uses the money she receives from Edwina to settle. So if she used that money to settle Win Finance, that means passing of title, feeding of title would happen, and then title could be passed to the dealer and then onward to Frank and the other people. But we're not told that. So if the Davinia did not settle the outstanding balance, then we're going to argue that title title is quite defective. There's no feeding of title. Uh, but in this case, we're not told, and we're going to assume that she has not paid that money to Win Finance. So they can sue for that reason because someone has sold something that belongs to them to someone else. They can sue under the Tort of Interference with Goods Act. And they'll be able to sue a party who has converted their goods, but they cannot sue anyone that comes in contact with that goods if that person has got good title. So in this situation, they could make a claim against Davinia. They could certainly make a case against Davinia. But as Edwina could not get good title in the agreement, she didn't get to good title. If the agreement was not paid off, then they could just sue Edwina for the conversion of their goods in the Tort Act. But remember, they cannot use both options. They have to choose one. They have to determine who to choose because they cannot double recover. It's only one item. They have to choose carefully who they want to choose. And one key consideration here is in relation to the cost of the goods at the time of conversion. So it's in their interest. That's what they can recover. How much was the goods when it was converted? So it's in their interest to sue someone earlier in the in the chain. It's beneficial to sue anyone earlier in the chain so they can maximize, get the highest amount. Remember, from 18,000, the car became was sold for 17,500, and then later it was sold for 10,000. So they might want to see someone earlier in the chain. And all these arguments are also relevant to if you're answering an essay question on this, because it's just a discussion of what the um it's a discussion of what the exceptions are and then what the remedies will be, even if it's an essay question. So in this case, we can see that if they were to sue Edwina, who has converted the goods by selling it to Frank, they may be obligated to allow credit for any increase in value that has been afforded by improvements made by Edwina. So if she has serviced the vehicle, if she has repaired it, they have to give credit for that. So that's a demotivator. That's one of the things that will not motivate them to sue under the thoughts of interference with Goods Act. In relation to Frank's situation, it's complicated, but it is clear that we have a claim against Edwina in one form or another. So now it depends on what we want to attack him from. In order to succeed, he must establish the basis of the claim. First, if Davinia paid off the HP agreement before Frank buys the car, then that means that there will be feeding of title. So the Davinia would be able to, Edwina would have good title rather if it was paid off before it was given to her, because Edwina is a dealer and Frank is a private purchaser. Where we have to look at the CRA, particularly Section 17(1), that he needs to have the right to sell. And breach of this is a breach of condition, and there's that statutory right to reject, going by Section 19(6) and 20 sub 3 of the CRA. If title had been fed, then Edwina won't be in breach of that right to sell to Frank, and that would just sort it all up. Now, if we want to look at this from the hire purchase agreement, which was not paid off before that sale, Frank still, it seems to have acquired good title because it comes under the exception of Section 27. He's a private purchaser going by Section 29 of the Hire Purchase Act, so he's able to get good title. Remember, the CRA does not make clear if the NEMODAT rules limit the availability of the statutory right to reject under Section 17. So we're not clear on that, but it would seem unlikely that the courts would interpret this to give more rights to consumers, uh, to give more limited rights rather to consumers. We're trying to protect consumers more, so that means the court will be expected to give them more rights, not less rights. So the right to reject definitely will be applicable. In the authority, in the case of Baba and NWS Bank, where the buyer in such circumstances acquired good title, someone like Frank, but the seller did not have the right to sell. It was still entitled to reject. And was one of the issues we talked about on Monday, that it's even in the interest of the buyer, a private buyer, to or a consumer to hold on to the goods for as long as they could, because there's no time limit to the right to reject. Furthermore, under the SGA, the right to reject in respect of feeding of title is likely to only exist until title is fed. I mean, we don't have any cases on that, but it would be the expectation that if you get good title after it's been fed, the hirer has paid off all the balance, then you can no longer claim and say there's been a breach of Section 12 anymore. You get what you paid for, you've got good title. Although we criticized that on Monday and said in the commercial sphere, if there's been an issue with title, it could be problematic to sell that item on. So those are some of the consideration. This principle has not been tested in the UK law, but we want to assume that that right would remain as long as the buyer repudiates the contract before title passes up the chain. So has title been fed? If title has been fed, it's really difficult for you to reject because yeah, you got what you paid for, bargained for. But we're certain the CRA does not explain whether the NEMODAT rules limit the ability of this remedy. It just provides that the buyer from a trader who sells under Section 17 can reject. So we don't know, we don't know what the law is, but we will not be surprised for the courts to limit the right to reject. And also, they may also not limit it when it comes to a consumer. But if they don't limit the right to reject, it just shows that it goes too far in protecting the buyer and can or potentially overcompensate for the loss because it means that it's in the interest of the buyer, the consumer, to hold on to the items for as long as possible because they know there's no limit to the right to reject. So we know in this case there's been a breach of Section 17 by Edwina, and if there's been a breach, you can claim damages. Uh, you can ask for a refund, and you may also be able to claim damages. In any event, we can see that Frank seems to have acquired good title pursuant to the HPA before she makes the sale to a second dealer, second buyer rather, Gwen. So there's non-delivery of the goods to Frank. He got good title, but because he slept on his right, this was sold on to someone else. So you can sue for non-delivery. And at this point, and you can also sue for the conversion of the goods under the tort because it got ownership, didn't it? Whilst the time for assessing is at the time for assessing value under the Torts Act is at the time the goods was converted. So it would be in his interest to sue earlier. So Frank will argue that the value of the goods was the price he paid for them rather than the price that was paid by Gwen, £10,000. So moving on from that, we argued earlier that Gwen could obtain good title as a second seller, second buyer when it's a sale by a seller in possession, as long as the Corvette was delivered to her, and as long as she was the buyer in good faith. We raised the issue that she might not have bought in good faith because she paid 10,000. That seems like a payment at under a sale at undervalue, and we also said that the burden of proof would rest on our to establish that they purchased in good faith because that should raise some questions for in our case. She might not have acquired good title if she bought not in good faith. And the authority on that is HEAP, 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 and Motto, and ISTS, Motorist Advisory Agency. It would be open to Frank to claim not only against Edwina, but as you can see that she's in financial difficulty, it just doesn't make any claim. But that would have been a better option for him in the sense that he could claim the full contract sum of 17,500, the cost of the car. But now that the car was bought by Gwen for 10,000, well, I think it's half is better than nothing, isn't it? Edwina is going through financial difficulties, so she may not even have anything to pay. So it's up to him really what he wants to do. Who he wants to sue. Does he want to sue Edwina? Does he want to sue Gwen? If the courts do not agree that title passed to Gwen by operation of Section 24, very likely the court should agree. But if they don't, because of good faith elements, then the courts could order that Gwen meet any claim for damages and return the car to Frank rather, based on the Tort Act. If Gwen is ordered to return the car to Frank, then she will argue that there's been a breach of Section 12 and she might want to sue Edwina for total failure of consideration. But we know Edwina has got no money to pay anyway. So, yeah, tough luck. Tough luck for Gwen. So we can see, based on what we've all discussed, different ways in which you can claim remedies here, the remedies that are available. There's a remedy of total failure of consideration where you can ask for a full refund if you're a consumer. You can also ask for damages for breach of that condition. You may also sue under the torts interference act. So your arguments will over between all those three. You want to think, is this a contract, in which case the CRA applies, or is it a, B2B contract or a C2B contract, which the SGA applies, and you want to apply the remedies. One thing you might want to note is that the remedy for consumers are sort of more robust, high level remedies. They get more protection. So you want to clarify that when you're answering that question. So I think that's the last question on that's the last question on the Nemo that. So we've answered an essay question and we've also answered a problem question. So I'll and stop sharing this and share another the next topic. So have you got any question on the Nemo that principle before we move on to talk about ru- um, passing of property and risk, which someone was very much ahead of the game last on Monday or Tuesday because they were asking about what happens. They were talking about the Romal part, retention of title clause, which is one of the things that is touched on here. It's not crucial that you discuss that in the assessment, but if you do, it's capable of elevating your performance. But don't go into too much detail. But it just shows that you really understand what we're on about. So if I can't see any comments from you, I'll just proceed to talk about passing of property and risk. So the CRA defers to the SGA for the point at which property passes. This is not something the CRA addresses, and it also does not deal with the NEMO that we just talked about. But when it comes to remedies, you have to go to the CRA because the consumers has more protection when it comes to remedies. Yeah. So the relevant sections of the SGA is 16 to 20B. In relation to the passing of risk, the CRA is very clear on when risk passes to the buyer. According to the CRA, if the buyer is a consumer, risk does not pass to them until the goods have been delivered. So the time of the contract could be at one time. It is not until they get delivery, physical delivery of the goods that risk passes to them. There is the exception of when they've allocated a carrier, they've appointed a carrier, the consumer. In that case, risk will pass to them. But let's get started. Again, if you're faced with a question on passing of property and risk, and this is a favorite among students going by past experience in the previous year, students really like this topic. I think they do well as well. So, and it's always a problem question. A contract of sale, you want to define that as a contract where there's been a transfer or an agreement to transfer property in goods for the consideration of money called price. So it had all those elements: transfer, property in goods, consideration called price. Those are the three main elements. So what is the meaning of property? And this is a question to all of you. What do you understand by the meaning of property? What does it mean? Is there any other words we can use to, okay, think someone ownership, very good. So property means ownership, the right, and the highest level, the way you exercise your property is the ability to dispose of the property of the goods. So that's the highest level through which you can exercise your right to property, the ability to give that to someone else, to sell it to someone else. And why is it important? Why is it important to know who has property? Okay, good. Let's see. General property. Okay, good. Yeah, general property. Good. In goods. So if the party in possession sells the goods before ownership passes to them, then the owner does not take title. And then we go back to the name with that principle. We go back to section 12. There's been a breach of a condition, etc., etc., etc. So one thing we would have realized based on what we talked about in your previous lectures and in this revision lectures as well is possession does not equal ownership. You can possess something. I possess this computer. It doesn't belong to me. It belongs to the MMU. So you can possess a car through conditional contract. That doesn't mean you own it. So for commercial certainty, possessing something, being in possession of something doesn't mean you own it. So possession does not always equal ownership. That's one of the fundamental rules. Now, when we're talking about why is it important, it is important for lots of reasons. So if we know who has property, we know who has risk. If we know who has property, we know who has an insurable interest in the thing. So if it's yours, you have an insurable interest in it. There are some exceptions. You can be in possession of something that is not yours, like maybe a car, on hire purchase or conditional sale. You can still insure, but who is going to bear the loss when that thing becomes destroyed? So what if you buy from someone who goes into liquidation? Remember in the question we just treated, Edwina she doesn't have any money. So if possession if she declares bankrupt, that becomes it becomes a problem. So yeah, what if you sell to someone that goes into liquidation? What if you buy from someone that goes into liquidation? So when property has passed, you as a seller cannot sell this item again. You can only sue for non-payment or for the price if property has passed. If property has passed also, the buyer can sue for non-delivery. So looking at what Section 649 says, it provides that where the property has passed to the buyer and he wrongfully neglects or refuses to pay for the goods, the seller may maintain an action against him for the price. That doesn't mean the seller can resell the goods. We see what that happened in the previous case. Although we need to know that it is possible to say in the agreement that payment can be for a later time. So property can pass before payment has been made. It's a very complicated topic. Now, still talking about why it's important, unless otherwise agreed, this is the provision. The goods remain at the risk of the seller until property passes therein to the buyer. But when the property in them is transferred to the buyer, we always say risk follows property. Risk follows property, except in consumer contracts. So you see that there. Yeah, happy to see that it's there in section 29. And know that you can divide title and risk. It can be divisible, but this is a general rule. So delivery generally means actual delivery to the buyer. Still moving on with that line of thought. Property can pass at different points, but this will be determined by the intention of the parties. And we can also look to the act to identify what the intentions are. You might want to buy goods, but not want them delivered immediately. In fact, that's the way the commercial sector work. You want to buy goods now, but you don't want to take delivery because you don't have where to put them. Just think about those people selling with Amazon. So they can buy goods, put it with Amazon, put it with Taobao, and then keep selling it. They don't even take delivery, actual delivery. So they just keep it there and sell it on. So you might want to buy something you don't want delivered immediately. Um, for example, someone buys a mobile phone that is damaged after the contract but before delivery. The question you want to ask is who bears the risk of that damage? Is it the buyer or the seller? The answer to that would depend on whether the person is a consumer or a business. If it's a business, we follow the sections 16 to 20 of the SGA. If it's a consumer, you cannot get property until it's delivered. I think that's section 29, if I remember correctly, of the CRA. So now, title and risk. If passing of property and risk are separate, but we know that when it comes to commercial transactions between B2B contracts, risk follows property. But in the assessment, please, please, please talk about this separately. Don't assume that because you've discussed property, you don't have to talk about risk. Because this is a common mistake students make. They assume that because risk follows property, they don't have to talk about it. Even if it's a paragraph at the end of your analysis on the passing of property, make sure you also talk about risk because if you do not do that, you will miss points for that. So, and you're going to see if the answer makes it clear. In the first one here, it just says advise the parties. But if it what when we say advise the parties, you still have to talk about risk because the whole discussion about property is because you want to know who bears the risk anyway. So don't forget to talk about risk in your analysis in the assessment. Right. So now, why do we need rules on title and risk? I mean, we said that before. We want to know who owns the property because it's the person that owns it that is able to sell it off, that is able to claim to it, and it could also help us determine who bears the risk of loss on damage. So what are the rules? Section 16 to 20, and this is where it becomes interesting. I must confess, I always enjoy reading your answers on this because it shows your high level analysis. I mean, talking about the previous set, I know you're also up to the task because it just shows your high level ability to analyze and break things down, apply the law to the facts using authorities, your sections as well as some cases. So we have different rules on when property pass. These would depend on if the goods are specific or unascertained. And when we talked about this on Monday, one of you pointed it out that yeah, I think we're talking about specific and unascertained in relation to what was that? Can't remember. Was it Yeah, we're talking about this on Mondays. Lots have happened since then. And some of you were really ahead of the game. We're talking about this. So title in goods cannot pass until they've been identified to the contract. So we know easily with specific goods, title passes at the time of the contract. But with uncertain, the goods have to be ascertained first by the seller with the assent of the buyer or by the buyer with the assent of the seller before they can be allocated to the contract. So this is the overview. If you're looking for a cheat sheet, this is it. So for specific goods, we look for the intention of the parties. If no contract intention applies, you follow section 18 rules 1 to 4. For uncertain goods, section 1 says you cannot transfer, property cannot transfer until the goods become ascertained. Then the second stage is section 17 say once ascertained, look for contractual intention. If you can't find any contractual intention, go on to talk about the rule 5 of section 18. So let's start. I want you to pop in the chat what you think specific goods are. So that television there, those 4 tomatoes, the one in the window. So these are goods that have been identified. That's the first step. They've been identified, pointed at, and agreed upon by both parties at the time of the sale. So what other examples can you give us of specific goods aside from these on the slide? That television there, those 4 tomatoes, that one in the video, in the window. Any ideas in the comments? Oh, I think we've got to okay. Let's see. Bottles of wine I have in my storage. Yeah. Maybe yes, but you want to say iPhone. iPhone is generic. Will shook. You might want to say my iPhone with the pink case, or my iPhone with the purple case, or my computer that I'm currently using. My yeah, yes, yeah. Bottles of wine I have in my storage. That doesn't you want to say maybe my all my 10 bottles of wine, the one I selected. Yes, that pen I selected. That, well, a desktop computer with that. Yes, not A. You won't say A. You say that desktop's computer with this serial number, because serial number is allocated to, we're going to see how this is very easy to identify what a specific good is. And I want to assure you that a vast majority of students, if I'm reading maybe 100 scripts, maybe okay, 200 scripts, maybe one person would get it wrong. Do you get the point? So for specific goods, it's very, very straightforward. Many students get it right. And if I wanted you to look at the pattern of what we answer in relation to this question, and able to get a feel of yeah, very good. Yeah, the gold coin I bought using my broker. Yes. If there's just one broke coin. So remember, you must specifically identify. The identity must not be in doubt, identified and agreed upon. So if you're saying a car with a specific registration number and license number, so you can say my car with this with this registration number. So I don't want us to sweat it. We're going to understand what this is all about. So when it comes to the sale of specific goods, the property passes at the time the parties intend, and regard shall be had to the contract conduct of the parties and the circumstance of the case. So, how do we know what the intention of the parties are? The Lord Diplock was the view that it should pass on delivery or payment, but other cases have held that we should look at rules 1 to 4 of Section 18 to understand how that is. So let's start looking at that. And you will have to do that. You have to apply these rules. I don't want to give you certain way of answering it, but you will. It's easy. Lots of students get the first two right. So you're going to apply to the contract for the sale of specific goods where the intention was not of the parties not expressed and cannot be inferred. So when we're not clear about what the parties have agreed on, we'll go to this. The first one says, in the sale of specific goods, that is unconditional. There are no conditions to be performed. There is nothing, no condition attached to the contract. Title passes at the time of the contract. So if the goods are in deliverable state, the property passes to the buyer when that contract is made, and it doesn't matter if the time of payment or delivery are postponed. Remember, we're talking about B2B contract here. It's very much straightforward when it comes to consumer. So delivery state was defined in section 61(5) as a state where the buyer is bound to take delivery of the item. And we've got some cases there. We've got Underwood and Berg Castle, where the item was screwed to the floor. Uh, yeah, so unconditional, Value versus Weeb, Denant and Skinner. If it's a conditional sale, a common example might be where the seller reserves the passing of title until payment. So this could go contrary to that. But that is a condition, isn't it? So if he decides the passing of title, that is a conditional contract. Rule 1 doesn't apply. So in section 19(1), it provides that when there's a contract for the sale of specific goods, or where the goods are subsequently appropriated or allocated to the contract, the seller may reserve the right of disposal until certain conditions are fulfilled. And in such case, pa- title will not pass until that condition has been fulfilled. So if it's a conditional contract, rule 1 does not apply. If it's unconditional, title passes at the time of the contract. And also rule 2 says when the goods are not in a deliverable state, that's what it's saying here. When the seller is a specific good, right? But the seller is bound to do something to the goods for the purpose of putting them in a deliverable state. Property will not pass until that thing has been done and the buyer has noticed. So this is a two-pronged test. If it's not in a deliverable state, first it has to be put in that state, and the buyer must have noticed that this thing has been done. In some answers, I've seen students interpret this rule, apply it really well, but then they don't talk about the notice part of it. And you will lose points for not doing that. So remember, talk about the notice. There has to be notice by the buyer that that thing had been done. So that's it for specific goods. deliverable state, undeliverable state, unconditional, conditional contract. Now let's move on to talk about uncertain goods. And this is where the bulk of your analysis will go into uncertain goods. These are goods that are identified only by description. And looking at the examples you've given, let's see if okay, let's look at a car, a car with a blue a 2004 model car, a 2024 model car. That's gen is uncertain. So any car that was um produced in 2004 would do. So these are really goods that are not, yeah, I think I'm so these are goods that are not identified or agreed upon at the time of at the time of sale. These are goods defined only by description, depending for their identification. If it needs to identification needs to happen after the contract. So one of those pitches, a car like the one in the brochure, order me that hi-fi magazine. Order me in a what hi-fi. Grow me some potatoes, a Hitachi widescreen TV, an iPhone computer, a no an iPhone, a an Apple computer. Those are uncertain. So anything matching that product will do. And we're going to see the sense in distinguishing between specific and uncertain goods. I think the definition has been that uh, goods that are not specific will more likely be uncertain. So section 16 provides that in the sale of unascertain goods, there cannot be passing of property unless the goods become ascertained. Because how can you say, oh, yeah, an iPhone, and say property has passed in an iPhone to you without you identifying the iPhone that is subject to the contract? So goods need to be identified and agreed upon by the parties afterwards. So that would be ascertainment. But when it becomes ascertained, then that's when we can talk about passing of property. And the court in Reweight said goods are ascertained when they are identified per the terms of the agreement. So when they are ascertained, no property will pass until the parties intending to pass. And that's why we have to look at Section 18, Rule 5, and determine what the intention are if that's not apparent in the contract. And in many of the questions that have been examined in the past, you often have to interpret based on the rules. You have to interpret based on the rules because the intention is not always apparent. So what does Section 18, Rule 5 provide for? It says that where there is a contract for the sale of unascertained or future goods by description, and the goods of that description in a deliverable state are unconditionally appropriated to the contract by the seller with the assent. Yeah. So let's look at the keywords here. In the sale of a contract, uncertain of future goods. So that's a keyword. There has to be unconditional appropriation, and we will see how courts have interpreted this provision in the questions we're going to be looking at. So what is unconditional appropriation? It is only when that has been done by the seller with the assent. So the buyer has agreed or the buyer with the assent. So assent might be presumed, it could be expressed or implied, but it has to be present anyway. So now talking about what we consider as unconditional appropriation. The first is it has to be that thing that has been done by the seller that there's no return from. So if there's a store that you said, oh, give me, yeah, let's talk about your example, the wine in your, yeah, let's look at the wine example. The wine, bottles of wine in my storage. So I'd like to buy one of the wines in your bottle of wine storage. Yeah. Wine, one of the wine bottles in your storage. So when does appropriation happen? Is it when you take a sticker, a sticky note, and write sold to Lee or I mean sold to Wong? No, because you can still go back and drink that wine. Nothing stops you from doing that. So it's not, it's a bit tricky determining when it's being unconditionally appropriated. So this is what the court said in Carlos Federspiel essay. This is a very good case to remember, guys, but don't worry if you can't. You can use any of the other ones as well. For Carlos, it's a really good case in terms of this because it says that the court says that setting us aside or selecting uh, by the seller of the goods he wants to use is not enough. If that's all, he can change his mind and use those goods in performance of another contract. Now, talking about the serial numbers you've talked about, you mentioned earlier in the comments. So if it's regarding a mobile phone or a computer and you've sent the serial number to the buyer, that means you cannot, it has become unconditionally appropriated because sending it to the buyer means you cannot turn back. But if you don't send it to the buyer, you can still sell the computer to someone else. And if you're a business person, well, I've done business in the past. My mom really was a business person. What they would do is, oh, maybe someone has agreed to buy something, and they said, oh, I'm selling this one in the warehouse. I'm selling this to that person. And you see someone coming to you with a higher price, and you're like, yeah, I'll sell this in the warehouse now, and I'll get other one. So that's what the court is saying in Carlos Federspiel, that setting it aside apart is not enough. More has to be done. So you got other authorities, which is providing of serial numbers. That would be good if you provided it to the buyer and they've agreed that you cannot, if anything happens, property has passed. So what it means is that in effect, the goods must no longer be under the control of the seller. That's when we can say that's unconditional appropriation. So inconsistencies I've been seeing in the case of Re London Wine and Co. and Re Ellis. We're going to see that too in answering the question. So I don't want to dwell on it now. The goods must be in a deliverable state. That's also another element of that rule. It has to be in a deliverable state. If it's not in a deliverable state, you cannot make an unconditional appropriation. And it has to be with the assent of the buyer or vice versa. So who is making the appropriation? It has to be with the assent of the other party. So if the appropriation is being made by the seller, it has to be with the assent of the buyer. And if it's being made by the buyer, it has to be with the assent of the seller. I think it goes, there's a very good example of this. When we go to the store and we're picking up items where we're still not owning those items until we've paid for them and they've been set aside, or maybe you're buying something on a Taobao. You can't say property as passed. If you're buying as a business, that is, you cannot say property as passed just because they've moved it to one side. Like I said, they could always change their mind. Now, if this is delivery in relation to delivery by a third party, Section 5, Rule 2 provides that the seller delivers the goods to the buyer or to a carrier and does not reserve the right of disposal, it will be assumed to have unconditionally appropriated the goods. Because you can't, if it's a third party that is not within his control, if it's being delivered by he himself, he can still change his mind, like my mom, and drive it to someone else's place because they're paying the higher price and you can always get other goods to satisfy your buyer. But if it's a third party, you can't call them back and say you want to get the item. So that would be deemed to be a unconditional appropriation. So Section 5, Rule 3 talks about appropriation by exhaustion. And that could go to the wine you talked about in your cellar, in your fridge. If there were five wines there and you said the wine in my fridge, one of the wines in my fridge, and you've taken four of them, we would assume that the last one belongs now, property passes to the buyer. So where there is a contract for the sale of a specific quantity of uncertain goods that are all in a deliverable state, when that bulk reduces to less to the quantity that the buyer wants to buy, then we can say the remaining goods are to be taken as appropriated to the contract. And we would then argue that the property in those goods will pass to the buyer. So I don't know. Yeah, there's someone typing something in there. I think that is that a mistake or something? So if only your goods are left in the bulk, it is automatically appropriated. If you have more than one order, even that adds up to that, we would say that has been unconditionally appropriated. So passing up property in part of a specified bulk. So if you say that's a specific bulk we're talking about, then section 20A is a relevant principle. It talks about undivided shares in goods forming part of a specified bulk. So we've got some illustrations of what this could look like in reality. So if the bulk is identified in the contract or subsequently, and at least some of the goods are paid for. So remember with the other ones, you don't need to have paid for the goods. But when we're talking about passing of property in a specified bulk, in part of it needs to be have been paid for, and the buyer becomes an owner in common with other ones. And this is a tricky one, but it's easy to understand. So in this example, buyer buys 100 oranges from a pile of 1,000. If he has paid for them, then he owns 10% of that 1,000 oranges. So if the seller sells 900 oranges, the remainder, the 100, will be deemed to have been unconditionally appropriated to the contract. So this is an illustration of that. Orange G's 1,000 oranges in stock, retained by seller 900, and the buyer has 100 of it. So if the seller sells 500 of the bulk and delivers them, then it will leave be with 20% of the remaining 500. He has a certain interest in 100 of anything that is left. So in this case, that seller sells and delivers 500 of the 1,000. So there is only 500 left. What that means is that the seller has 80% of the bulk, which is 400, and the buyer B has 100%, which is 20%, 100, which is 20% of the bulk. If you're buying as a powder bulk and the seller has unsold goods in the bulk and they are if these are destroyed, so let's go back to the previous slide. So if out of the 500 remaining oranges here, 300 are destroyed, then we know we have 200 oranges left. The assumption would be that the seller now has 50% of the remainder and the buyer has 50%. Nothing is happening to the balance that is owned by the by the buyer. Another scenario, if 400 are destroyed, we would assume that the seller has no oranges left and the 100 that is not destroyed belongs to buyer B. Yeah, I think this is so. What if 500 were destroyed and 300 remaining were what if 300 of remaining 500? What if 450 of remaining bulk of 500 is this of what if he sold 450 of the remaining bulk to C? He has infringed on the interest of buyer B because he has sold the goods belonging to buyer B. So buyer B now has to sue him for non-delivery. So let's look at a situation that doesn't involve the seller, but involves the buyer and other buyers. So we have buyer B that buys 200 and buyer C buys 300 of the 500. What will happen if there is a partial destruction of that 500? So say uh, out of the total, we know 20% belongs to one, 30% belongs to one, 200, 300. If the bulk is reduced to less than the owner's amount, then all owners will take a proportionate reduction So assuming that 100 tons is destroyed, it will be shared in the same proportion of ownership amongst the buyers. So buyer B will lose 40% of their, because they own 40% of the balance anyway, and buyer C will lose 60%. So they will lose 40, 60 respectively. We're going to see how that plays out in this scenario because I think this is one of the things that is examined in the revision question. This is the part I said you should not forget to talk about when you're answering the question. You want to refer to property usually follows, risk usually follows property, and that's what section 21 provides. Remember, you can agree otherwise, but if you do not, the goods remain at the seller's risk until property is transferred to the buyer. But when the property in them is transferred, then the risk will be transferred as well, whether delivery has been made or not. But there are limitations which can be found in subsection 2. If there has been a delay that is the fault of one of the parties, it is the party that caused the delay that will be affected, that will be responsible for that. Custodian must also take reasonable care if they don't want to be liable. But remember what I said, Section 29 of the CRA says a buyer does not, risk does not pass to the buyer until it's been delivered. So that's straightforward when we're talking about consumers. This is the provision of the Act. Uh, yeah, so I think that was yeah. So so those are the provisions of the Act, and then we'll move on to the next one. So impossibility. You can listen to that. It was recorded by someone else in the past. Did you hear? Do we need to mention CRA? I don't think you need to if it's a B2B contract. Do you understand? Do you understand? Yeah. If it's a B2B contract, you're just seeing this as if you can if there is a consumer in the scenario you've been given, then you want to apply Section 29. It's straightforward. If there is a carrier appointed by the consumer, then of course property would have passed to them. But if not, property will not pass until they've got physical delivery. Now, higher level, top level answers deal with this. This is one of the ways students distinguish themselves. By talking about, yeah, is that a question there? Do we need to, does the seller absorb destruction approach applies to both B2B and B2C contract? That's a very interesting one. But remember that risk does not pass to the consumer anyway, Huey. So, ownership in a bulk, risk does not pass until the consumer gets actual delivery, right? So even if property passes to them, risk does not pass. Yeah. So top level answer will deal with this. Talk about frustration. Section 6 and 7 really deal with the common law principle of frustration. So if there's a contract for the sale of a specific goods and that goods does not exist at the time of the contract, that contract is void. So default lies where it falls. If it's a contract for an illegal item, you're trying to buy a gun when it's illegal to buy a gun, the contract is void. um you cannot sue for delivery. No, you cannot sue anyone. And the authority for that is Katuri versus ST, where Katuri, where the goods of the con are deteriorated by the time of the contract, the court said, yeah, that's frustrated. The contract, no property pass is void. Yeah. And section 7 as well. This talks about if after the first one, section 6 is about before. Section 7 is if after the contract there is a um, destruction, there is a frustration of the contract because the goods no longer exist, then if this is not because of the fault of either of the parties, then the agreements can be avoided. And you can see the sense in this. In the first one, section says the parties are agreeing on a contract that does not exist, or on goods that do not exist. How can you sue for non-delivery of goods that do not exist? It can never be delivered in any way. And in this case, if you're talking about, okay, yeah, we've made a contract, but it becomes destroyed as a result of something else, not because we've done something wrong, each of the parties, then you cannot sue for delivery because it's a specific good. Is that pink iPhone? Is it the wine the wine in my fridge? It's just one wine. It's specific. So this is a sense in it, and it goes to the topic on frustration of contracts in contract law. So high level questions, answers rather, talk about those in the assessment. So I want to quickly say if we can finish one question before we draw the curtains for today. So that means on Monday we'll be talking just about exemption clauses. I mean, answering the second question, we'll talk about exemption clauses, answer questions on those as well. And then yeah, void and avoided. So avoided means give notice that you want to get out of the contract. So that's you. This is the same way you avoid a voidable contract. It's the nuance. It's the same way you avoid a voidable contract. So you don't need to pay any remedies whatsoever, providing you can prove that it is due to no fault of either parties. If it's due to one of the parties' fault, then of course you may be able to claim damages for that. So the distinction between the two is one is before the contract is entered into, and the other is in relation to after the contract has been entered into. So let's look at this question, transfer of property and risk. I want you to put in the chat the main issues you've been able to discover. It will be really great if you can identify the relevant provision in your chat so I can see that you really have a good grasp of this. I don't want it to be all one-sided. And if you've noticed, since we started, my approach has been to um get you to engage, get you to talk about this, just so we're we're sure that we are all getting it right. So pop in the chat the main issues you've observed in the question, and also you may want to comment on the relevant sections of the act. Yeah, so I can see that the comments are coming in. Keep it up. Yeah. So the starting point, yeah. So let's see what you said. On Monday, I'm going to tell you again the same thing I've said about it. So rest assured about that. So it goes, you need to talk about the types of goods. Um, so notice, I don't think that's what the act provides for. I don't think that's what the act says in relation to avoiding that contract. You just have to look at the provision of the act, and you look at the provision of the act and see what it says in relation to that. Remember, the act is the primary document you want to refer to. So you're saying B2B and mixing the questions, so the buyer must give notice to, okay. Yeah, so I want to see more comments on this. The starting point is to identify the main topic. This is in relation to the passing of property and risk in goods, and you want to reiterate the importance of determining when property in goods passes, as this is often the point where risk passes in business to business transactions. The situation could be different for business to consumer transaction. So you're saying 10 for his business and one for his daughter. Okay, so that's a very good point. Hung, what all in favor of this being a B2B contract that is governed by the SGA or a B2C contract? Can we put that in the chat? Because it's a mixed contract, isn't it? The intention of the parties, yeah, that has to be. So you're saying 10, he bought 10 for the and one for the birthday of his daughter. Is it this question? Adam agreed 10 for his business, one for his daughter. Ben agreed to buy. Yeah, yeah. So even if it's the we're going to say this is wholly for a business sake, and we're going to proceed with our discussion. But even at that, the CRA does not deal with the issue of passing of property. So the bulk of your discussion will be the SGA anyway. So if you, peradventure, you think the CRA is relevant, then it will be on the passing of risk. CRA consumer, there's no such thing in CRA consumer contract. I don't understand intention. CRA consumer, is that meant to? Okay, so let's move on and talk about this. I know we're all tired. I can see that emoji. So 25 more minutes to go. We'll be done. Don't worry, guys. So we're saying the CIA does not deal with passing of property and risk, except in the case of passing of risk in the B2C contract. That's relevant. So pursuant to Section 20, unless otherwise agreed, the property remain at the seller's risk on property in them as passed. We know what that provision is. But going by the CRA Section 29, where the buyer deals as a consumer, then this rule is displaced and the property risk will be with the seller until the buyer has physical delivery. So the rules which apply depend on whether the goods are specific or uncertain goods. The main point in this case is that it is wholly for a business. So he's buying 10 things, isn't he? And those 10 things could either be, those 10 things are a B2B contract, and then one of them is for a consumer. So it is wholly for the purpose of the business. So we're going to apply the SGA to this. So going to the issue of whether these are the rules that apply, you want to talk about this will depend on whether the goods are specific or unascertained. We see that he bought um 11 computers, 10 for his business and one for his daughter's birthday. And he has had the model demonstrated to him in the shop. So that means these are uncertain goods because they have not been identified with and agreed upon at the time of the contract. They've not been identified and agreed upon at the time of the contract. So the contract um, is for any 11 computers fitting the models. The goods are identified only by their description, and later they need to be ascertained before they can be uh, assented to. See that types of goods makes no difference in the context of the CRA. So when it comes to, oh, you're saying whether it's specific or unascertained, on what basis would you say that? On what basis? Because it's the reason we're discussing ascertained specific is to determine the passing of property. The only thing commented on by the CRA is the passing of risk in a B2C contract, passing of risk. So we would have talked about passing of property anyway, and that's governed by the SGA. Oh yeah, so it doesn't matter. It doesn't matter anyway. You know, with the SGA, risk follows property. With the consumer, risk doesn't move until it gets to the buyer. Is get delivery. So I don't think that's a discussion you want to explore. It's not necessary because the CRA does not discuss the issue of passing of property anyway. So you still have to go through the motion with the SGA before talking about risk and applying the SGA. Yeah, with the CRA, sorry. So moving on, any computer, these are unascertained goods. So you want to ask, how do we determine when a property passes in unascertained goods? Section 16 says that um, in the contract for a sale of unascertained goods, property will not pass until the goods have been ascertained. And when they've been ascertained, we have to look at what the parties agreed to. And the authority for that is reweight. The goods here have not been ascertained at no point because the goods have been identified. This means that the property in the goods have not has not passed from SIA to Adam. So the risk will therefore remain with SIA, and Adam will be entitled to sue for non-delivery if SIA cannot provide replacements for the goods within the specified period of time. And the reason he's able to sue for that is because these are unascertained goods. So there is no question of frustration arising because SIA can source them again. So if you were to be specific goods, then we can talk about sections 6 and 7, but because it's unascertained, then there cannot be any issue of frustration. So that's the thing with the 11 laptops. Now, in relation to Ben, he has agreed to buy 5 personal organizers like the ones on display. So again, he's describing the item. So 3 were for employees of his business and 1 each for himself and his wife. So these again appear to be uncertain goods because he looked at a display model and ordered 5 new ones. So the shop can supply any any 5 new personal organizers under the contract. The goods are only ascertained once they are identified in accordance with the contract. Notice here that it doesn't appear to be so from the question, but if Ben and Sia sales represent the sales representative agree at the time of the contract that there are only 3 remaining in the warehouse and no more, and that Ben will be given those 3 remaining from the warehouse. It will be a contract for specific goods. And that's the example you gave earlier when you were talking about the wine in your fridge. So if it's just one wine, then we know that's specific. So if we have just 3 from the warehouse, then those 3 will be uh, determined to be ascertained. So the wording of the question suggests that the manager only has the warehouse staff to remove the warehouse stock after the contract is entered into. So this would appear to be uncertain goods because it wasn't agreed and identified at the time of the contract. So the rest of the answer will proceed based on this. So the shop manager here has asked the warehouse man to take 3 personal organizers from the warehouse and leave them in the dispatch area to delivery to Ben, and also ordered a further 2 from the main source supplier in Japan. So now we need to determine whether this amounts to unconditional appropriation or ascertainment in accordance with the contract. Even when ascertained, no property will pass to the buyer until the parties intend them to pass. And if there is no intention clear from this, then we have to apply Section 18, Rule 5, which provides that in a contract for the sale of unascertained goods, future goods by description, and goods of that description are in a deliverable state, and they are unconditionally appropriated, that is when property may pass. But look at this case. There are two main elements. They have to be unconditionally appropriated, and this will need to be done with the assent of the other party. Remember the two cases we talked about, the Carlos Pederspiel and Charles Twig, where the court said that goods are appropriated to the contract when the parties had an intention to irrevocably attach that to the contract. It was noted in that case that merely setting aside or setting apart the selection by the seller is not enough. And if you think about the example I gave you, you can always sell that on and get other goods to satisfy the contract. The buyer would not know, would they? So if that is all, he could always change his mind and use that contract otherwise. And if you write the names of the customer on the goods, you can always remove that and still sell the goods. So moving on to talk about the case of London Wine Co., a wine merchant who sets aside a box of 12 bottles of wine in the warehouse to fulfill a contract was held to not have irrevocably appropriated those things to the contract. And he also did not do that when he put it in the van for delivery or when he writes the name on the delivery label. The court said he had done nothing that he can't change his mind about. So that shows the extreme how we construe unconditionally appropriated. And it would seem here that the SIA has not done anything irrevocable to appropriate the goods to the contract. So this would not be the case if the order had been identified, and yeah, the personal organizers can be used in the contract. We could look at the case of Hendy Lennox and Graham Potix Engine, where the seller sent an invoice showing the serial numbers uh, of the engines to be delivered. And it was in that case the court said the goods were indeed unconditionally appropriated, because if they are delivered, the buyer could all look at the serial numbers and say, you know what, this is not what you sent to me. These are not my goods. So property would have passed in that case. So here, it would seem that none of the five items had been appropriated to the contract, so the property and the goods have not passed to the buyer, and therefore the risk will remain with the seller. This also applies to the ones ordered from abroad, because you could use that for other purposes as well. Like I said, business people do this all the time. So Ben, in this case, could sue for non-delivery of the goods if they are not delivered by the time stipulated in the contract. So again, we cannot apply the doctrine of frustration here because the goods are uncertain. They can be sourced elsewhere. They're not specific goods. So moving on to talk about Claire. She agreed to buy the X demonstration model for her business. So SIA went to install all the necessary software on the computer before delivery. So this is a specific good that requires something to be done to put it in a deliverable state. So you can think about the relevant principle that applies here. So we want to start by talking about Section 17, which applies to passing of property in specific goods. Section 17, you can talk about the provision, which is to the effect that the property in specific goods pass when the parties want them to pass. And Section 17(2) said we should have regard to the contract, the conduct of the parties, and the circumstances of the case. You can look at the authority of Ward, W-A-R-D, and Bignall, in which Lord Diplock said, in modern times, very little is needed to give rise. That quotation is in the slide. Here, in this case, delivery and payment are separate rather. So it may be difficult to find intention from that. But if no intention can be inferred, we have to refer to Section 18 that lays down the four rules 1 to 4, that will help to guide us on what the intention of the parties may be. So rules 3 and 4 are not relevant because do you have to differentiate between B to C contract? For the purpose of passing of property, no, because even in a B to C contract, the CRA does not say anything. We've said that before, but it only talks about um, passing of risk. In the first issue, it's just one laptop. In the grand scheme of things, compared to the other 10, yeah. And we said in the first one as well, it wasn't appropriated, so we don't even have to talk about risk. Um, Frustration cannot be applied to questions A and B on the work. Yep. So I can talk about that. I hope I'm still able to run through this. So frustration, the way the doctrine of frustration works is that frustration is when it is impossible. It is not when it's difficult, no. When it is impossible for the contract to go ahead. So if you've entered into a contract for the sale of your Chevrolet, which I'm selling my Chevrolet to you. It is just one Chevrolet. It is specific good. So if that car has been bought at the time of the contract, it is impossible to deliver it. Do you understand? So frustration is only possible for specific goods. But when it comes to unascertained, if property has not passed as a seller, the argument is it may be difficult for you to order for similar goods. It may take time, but a contract is a contract. You can always source for those items elsewhere. It is not impossible to complete the contract. Do you get my point? So frustration is possible going by section 6 and 7 and the common law is only when it is impossible. And when it is specific good, it is impossible. But if it is unascertained, a 2024 model car, if the model you think you want to sell has been destroyed, you can always source for other ones to sell. Do you understand? So it would be a burden on the seller, yes, but is still able to get it. But compared with specific goods, it's practically impossible to get that good because it is specific. So I'll continue. Um, Rules 3 and 4 are not relevant because they relate to measurement, weighing, and all and etc. So we're going to focus on rules 1 and 2. Under Section 18, Rule 1, when there's a contract for the sale of a specific goods and it's in the deliverable state, property passes at the time of the contract, and it doesn't matter that both payment and delivery or both are postponed. In relation to Rule 2, when there's a contract of sale in a specific goods and something needs to be done to put them in a deliverable state, doesn't pass until that thing has been done and the buyer has notice. So we want to ask ourselves, what's the meaning of specific, unconditional rather? Section 61(5) of the Act it means no condition which prevents property from passing, and deliverable state is delivered as a condition where the buyer is meant to take delivery. So, in the case of Underwood and Burke Castle, an engine that was fixed to the premises of the vendor was not in a deliverable state at the time of the contract because it had to be unscrewed. The sale of a loose chattel was what the envisaged. So the engine has to be dismantled. So something has to be done to put it in a deliverable state. So here, the software has not been uploaded. So that means that's not in the deliverable state. And the rule 1 does not apply, rule 2 applies. So property will not pass until that thing has been done. We would need to establish if the software was uploaded in this case and if it was uploaded to the computer before the fire and whether, so remember I said when I was talking about this, is a two-pronged test. The first thing is, has the software been uploaded? Does Claire have notice of this? And it's a conjunctive demand. We need it to both tests to be complied with. So unless both apply, then we can say that she will be entitled to sue for non-delivery because that software has not been uploaded, property has not passed. She doesn't bear the risk because property has not passed. But we can see, I mean, the act says that unless there's a contrary intention, that's not evidence in the contract. So we don't, well, she will be able to sue for non-delivery. And if the contract is entered into after 2015, she will not be able to then. Claire will not be able to argue that she's a customer because she purchased this computer for her use for using her business section 2 to be a consumer. It would have to be purchased for purposes wholly or mainly outside her trade or profession. So in non-consumer contract, unless a contrary intention is apparent, by virtue of section 21, property and risk go together, and it looks like property has not passed here, so risk will still be with SIA rather. But this is an agreement for the sale of specific goods pursuant to Section 7, where the goods perish post-contract, but prior to risk passing to the buyer. So the contract is avoided. There was an arson attack, and all goods were destroyed. So they will have perished. So that means it was after the contract was concluded. That was when, not really, you said unascertained goods, the entire bulk is destroyed. You might want to expand on that, Hong. You might want to expand on that. So this is an agreement for specific goods pursuant to Section 7 because it is an display. Let's look at, yeah, X demonstration computer, which she, yeah, to buy their X. So it is specific, but at the end of the day, it wasn't, it was destroyed after the contract. So this is what a top-end answer would do. That answer will consider the relevance of section 7. So in the case of ASFAR, let's spell that ASFAR, and Blondell. Now I have to be sure to finish before the contract will be avoided, provided the risk has not passed, and if arson is not the fault of the seller. In the Law Reform Frustrated Contract Act does not apply in this situation because Claire has paid for the goods but received nothing. She will be able to recover our price on the basis of total failure of consideration. So that's how she's able to avoid the contract. She can get her money back. So moving on to talk about Dan, I think that's the final one. He's setting up his business with his neighbor and wants to buy those computers. So Dan has agreed to buy 3 of the 4 computers in stock, and this means that the shop should supply any 3 of those 4 computers. And we go to what we talked about in relation to possession of a power of a bulk. So she has 3 of the 4 computers. So that means he has 75% undivided shares in common with Sia. So section 20A applies because the bulk is specified and Dan has paid for the goods. That section is silent on when risk passes, and it has been suggested by Scruton LJ in Stearns and Vickers that the transfer of an undivided share in good should also carry transferring risk. But it is generally thought that since 20A is silent on the matter, property will pass under section 20 only when property does under 18 Rule 5. But we see here that there is nothing left to be done to the goods to put them in a deliverable state, and it is an unconditional contract. The goods will pass when they are ascertained, and the goods can be ascertained to the contract through exhaustion. So if he has taken one out of it, that means the rest will belong to the company. I'm trying to see if I could finish that to now, but I've seen that lots of questions have come in here. Is this a contract? It is avoided because In answering the question about whether it's avoidable is voidable, sorry, whether it's void or avoided, it is void when that thing d is destroyed before the contract comes to an end, before the contract is entered into. So Katuri versus Hasi, at the time they were entering into the contract, that thing no longer exists. So Section 6 is relevant if it's destroyed before the contract. Section 7 applies if its specific goods is destroyed after the contract. So I hope that clarifies the distinction between the two. Kane, is this contract, in this case, it was destroyed after the contract was entered into. So to be able to avoid the contract, she needs to give notice because this doesn't fall under one of the exceptions. We can revisit it on Monday. I can restart from. Okay. Yeah, okay. I think it seems like you get it. Yeah. So let's see the other comments. Yeah, I think I've answered that questions. So you're saying not really unascertained goods, the entire bulk is destroyed. Yes, it's uncertain, but what about what we said, an identified portion of a specified bulk hung? It says here, um, was in the process of, he had agreed to buy three of the four. So there's a specified bulk. So is that analogy we created will be relevant? So the answer to the question D, no, we've not finished talking about question D. We're still talking, we've finished talking about question C. That's the one we said is it can be avoided. We're still discussing question uh question D. Do you get my point? Do you understand? We've not talked about question D. That's the one I started with, but I just think it's the end of the time our time for today, and I don't want to hold you for longer than necessary. But do you need further clarification, Wong, before we close for today on question C? Remember, it's a specific good. Okay, great. So you understand. So that one it could be avoided. As always said, applying rule two. The property in good will not pass until that has been done and it's been uploaded. And we said she will not be able to argue that because she purchased it basely, mainly for use as a consumer because it's wholly for a purpose outside of as a non-consumer contract is wholly mainly outside of our trade, but that's not the case here. So in non-consumer contract, Section 21 applies, and we're saying it's an agreement for specific goods pursuant to Section 7. So there was an arson attack, and all was destroyed. So the contract will be avoided, provided risk has not passed, and the arson is not their fault. So the Law Reform Act does not apply in such situations, those other ones. So in this case, Claire has paid for the goods but received nothing, so she will be able to recover her purchase price on the basis of total failure of consideration. You might want to have a look at the authority, the Fibrosa, Fibrosa, and we'll come back to discuss that before moving on to D on Monday. So if you have you got any other questions? I know I've taken more three minutes. I feel bad about that. But if you've got no questions, you're free to leave for today. See you on Monday when we answer the second question, and then we address the final topic, which is exemption clauses. You also will be looking at a student essay written by students, and we'll discuss the mark given to the students. All right. Yeah. So, or yeah, you're free to all leave. Um, I'll stop recording now and stop sharing first. And stop.